Hello, thank you for joining us for this quick 10-minute talk. My colleague Nick Leale, who's one of our professional discipline and regulatory specialist partners here at CM Murray, was at the Law Society's Risk and Compliance Conference last week, and he and I thought we'd have a quick catch up to find out what's on the agenda from a risk and compliance perspective for law firms at the moment. So let's get cracking. Nick, must have been interesting for the attendees to hear from the SRA's new chair. What were her key messages?
Yeah, the CEO, Sarah Rapson. It was only brief, but as far as the key message is concerned, I think one was one of her opening comments, which was, and I quote her, "The current regulatory model is unsustainable." And she went on to talk about how the number of misconduct reports has rocketed. Latter part of last year, reached about 3,000 a month. And I think something close to a 45% rise in investigation caseloads year on year as well. And I think she accepted that indicated a problem for the regulator in its triaging, and it wasn't lost on her, particularly given the fact that they were overwhelmed even a year ago with regards to the number of complaints they were dealing with. That led her to sort of majoring on the SRA's need to move from being a reactive enforcement-led regulator to one that, as she put it, proactively supports compliance. So supporting firms to comply rather than punishing them for failures. And she was very clear that enforcement should be reserved for those who are really, again, I quote her, letting the profession down. And she talked a lot about how the SRA needs to learn to use the other tools available to support compliance. And there wasn't really sufficient time for her to expand on what that new support might be, or how the organisation may transition to the new system. But it was clear that her mind was made up, really, that there was a step change needed urgently, and it couldn't just clip around the edges of the current scheme. So I think what she was trying to say and what can be expected is better guidance, better control, better support for cults, more monitoring, more proactive supervision. And I think we should assume that means intervention that supports compliance rather than lead to immediate investigation and sanction, I think. And it'll be interesting to see what resource they're prepared to commit to that, which wasn't clear because she didn't really have time to talk about the detail.
No, and they may not have the detail yet, of course. That's really interesting, though, and it all sounds very, very positive. I mean, one of the difficulties the SRA has, of course, is the criticism that they've faced recently. They've been strongly criticised for a number of things. I mean, Axiom Ints, SSB, the enforcement action that they're taking, or the enforcement action that they're not taking or weren't taking. Did she express any views on sort of how on those issues, the criticism that they've faced?
Of course, there have been a number of unsuccessful prosecutions and a number of cost orders as well. And I think she was absolutely clear that she wanted to have a conversation through the course of this year on what the SRA should act on and what they shouldn't act on. And it was very much a change of tone from what senior management used to say. I mean, the fact is they've got an issue with an unsustainable number of incoming reports of misconduct coming onto the system, and they want to support rather than punish. So I think what's clear is that they will want to move to some sort of graduated framework where if something isn't causing serious harm to consumers or isn't dishonest, then they will look to an alternative to formal enforcement, I think. And that was supported by her comments in relation to Mazur, which I think best demonstrated it. She made it very clear that the SRA will, under no circumstances, pursue those who, as a result of what's gone on with Mazur, were inadvertently on the wrong side of the rules around conducting litigation. So it's a complete change of tone. I think her predecessor used to often blame the laws drafted outside of the SRA in relation to what they did with regards to AML enforcement. And I think that they were also under some pressure internally to meet targets of enforcement. But this is something completely different, potentially, I think.
Thinking about other hot topics that we're seeing in the risk and compliance world, we can't not talk about technology and about AI. I know that the SRA's view had always been that AI is a huge part of the future of legal services, and that technology represents the future of legal services, but that they hadn't quite gone far enough to, for example, provide detailed and meaningful practical guidance on the use of technology, or indeed to amend the rules to be able to accommodate those advances in technology. Did Sarah Rapson shed any light on these topics?
Well, she didn't really offer much in the way of comments in relation to that, but it was the part of the day that talked about AI was probably one of the most interesting parts of the day, because they had a panel, and that panel included people from the big PII firms, the big insurers. And it was interesting. There was a poll done. They did a number of polls through the course of the day, which showed that probably half of the people there thought that AI use and the management of it was the responsibility of the individual. Very few thought it was an issue that came down to senior management. And the PII brokers there were particularly concerned about that, I think. And what became clear is how much they wanted AI to be embraced by law firms, but they also wanted to see clarity in relation to supervision and verification, and a real understanding on the part of everyone within the firm of the issue of security and the need to protect client data. And what became clear was how much they want to see on renewal of policies, AI policies, and clear answers into how it is being used, and not vague comments about AI being experimented with. So, real emphasis on the need for all firms to have a proper risk framework around AI, and a proper policy that's created with CULP input, I think, it being a policy for the risk team as well as the IT team, and very clear controls in relation to usage. What was particularly interesting was how concerned insurers are where they hear a firm may have banned the use of AI, because they saw that actually as something that greatly increased risk, because it just meant that people were using it without guardrails.
I can see the logic in that perspective, certainly. And the other hot topic in the SRA and risk and compliance world for law firms at the moment is obviously around the supervision of anti-money laundering. Obviously, it was at the COP and COFRA conference last year that we all heard the news about the switch from AML supervision from the SRA to the FCA. So we know that's coming. What was the mood in the room about those changes?
Well, I think people are concerned because they don't know the detail. There's a level of uncertainty in relation to it. I think what became clear from that session is that those who are closer to it think that could easily be 3 years before the FCA becomes the sole regulator of the AML regulations. There were ongoing concerns about the issue of double jeopardy, how somehow that's going to be avoided when the FCA takes over the policing of AML breaches, when the SRA deals with breaches relating to the accounts rules. People were fearful, I think, when they heard about how big the FCA's powers are, the ability to fine 20% of turnover and also recover the costs of third-party audits. But I think what it came down to is what encouraged people more is that the FCA is more data-led, less tick box-led. They will want to see more that the system is working. So they want to see records of how you can show the system is working and how unusual issues are dealt with, which is good, obviously, for those who are sufficiently set up and sophisticated in relation to it all, a little bit overwhelming for those who aren't. But I think also people were encouraged by the fact that the FCA's focus is likely to be less on technical breaches, particularly those made at smaller firms. And I think that balanced the fears that I've sort of expressed above. I think there's also going to be, I think people think and appreciate that there'll be a strong correlation between candid reporting and then there being no sanction or enforcement by the FCA, which of course is completely different to the SRA's current approach and is definitely something that everyone wanted to hear. So I think it was a mix of worry about how it would actually work with some encouragement of the fact that the FCA scheme is very sophisticated, perhaps doesn't focus in on technical breaches quite like the SRA schemes does at the moment, and will reward those who have good policies and can show that they can work.
Mm, absolutely. That's really interesting. Thank you. So, I mean, this is one of the flagship events for the risk and compliance world, obviously attended by many senior, experienced law firm risk professionals and GCs. Did you get any sense about how people are feeling about law firm risk management and SRA regulation generally, just to wind up?
I think people are hopeful. I think they're encouraged by the approach of the new CEO, Sarah Rapson.
Mhm.
I think I think everyone's pleased that she's definitely still in listening mode, keen to work with the profession. I think it's appreciated that the SRA would appear to be moving to a position where it more readily accepts that they and the profession have a shared objective in maintaining trust and confidence in the profession. I think, though, that until people see, I think this is the feeling I got from talking to people around the place.
Mm.
I think until people see more than words, particularly with regards to the FCA oversight of the AML regs, and AI. I don't think that the COLPS GCs and senior leaders who were present will really be able to say that they have real confidence, renewed confidence in the SRA until they see what the SRA actually means by what they've said and has done, actually made progress in relation to it. What actually Sarah Rapson means when she says that they want to put to use other tools to proactively support compliance. I think people there certainly appreciated the sentiment. They felt encouraged that the profession was being listened to, but are awaiting evidence. I think perhaps people were expecting to have heard a little bit more substance now rather than just talk. We've seen things like the firm risk profile, a document that they want to use in order to hopefully prevent more SSB events. But I think everyone does, though, accept that it's going to take time to transform the approach and transform the organisation, given all that's gone on over the last few years.
Looks like they can talk the talk, but we still need to wait and see if they can walk the walk. That's really interesting. Thanks
Yeah.
so much, Nick. Um, Great. Well, look, we promised a quick chat, so let's leave it there. Thanks, Nick, for those really interesting insights. Thank you also to you for joining us for this really quick chat. If there's anything that we've chatted about that you're interested in chatting about more, or if you've got any questions about professional law firm regulation or professional discipline, then please do feel free to reach out to me or Nick. Thanks very much. Bye bye.